All right, once again, we have Richard DeBoest of Goede, DeBoest Cross gracing us with his knowledge and experience. Thanks, Richard, for coming on.
Thank you, Derek.
All right, so this time of year is a huge reason to look back, but also to look forward. My recent, as I was just mentioning to you, my recent radio show, I did kind of a look back into 2025 and looking into the future for 2026 and kind of some of the things that I think are coming down the pike. But obviously, legally, this is your lane. So I'd like to ask you first, maybe looking back into 2025, what do you see as some of the most important changes over the last 10 months now, 11 months now?
Sure. Well, primarily, all the legislation that affects community association laws in 2025 was out of one bill that primarily only affected condominiums as far as changing Chapter 718. There was some additional changes to Chapter 468, which is CAM management, which does affect all community associations. But the biggest changes were all Chapter 718, and there has been a lot of press about it, and then a lot of confusion because people think that applies to their HOA, and it doesn't. One of the biggest ones is the new video conference law, which I think you and I have discussed before.
Yeah.
The primary thing to keep in mind with that is this, which I will explain briefly what that is. The video conference law, this only applies to Chapter 718 condominiums. Does not apply to 719 cooperatives, and it does not apply to 720 HOAs. There's a lot of confusion because a lot of the newspaper authors and writers, they don't make the distinction. They think condos, co-ops, HOAs are all just one big happy community association. And there are, as you know, very distinct different statutes, which are similar in a lot of respects, but different in very significant respects, particularly in this video conference law, which, again, I'm going to reiterate, only applies to condos under 718. Presently, do I see it being morphed into the other statutes? Probably, because they eventually will catch up as they do. And we've talked on the previous podcast. They seem to focus on condos or HOAs. They leave co-ops out of it. And then eventually they realign everything. And then eventually they unalign it again. And we go through this round and round and round. But very briefly, the video conference law, first of all, they define what the term video conference is. It's a video and audio enabled platform, which you hold a board meeting, a committee meeting, or a membership meeting on. Think of the typical Zoom or GoToMeeting or Teams. You have video and audio capability, both enabled. That's critical. If you are going to hold any meeting, that's a board meeting, a membership meeting, or a committee meeting with video conference enabled, video and audio enabled, there's a couple of requirements. Number one, you must record the entire meeting, start to finish. You must keep that recording for at least a year and post it on your website if you're required to have a website. So the workaround that we see at the moment would be, remember that word, video and audio enabled. So theoretically, if you only have the audio enabled, you don't have to record the entire meeting, which we don't think is a good practice. And you don't have to do other requirements. But the basic requirements are this. Not only do you have to record the entire video conference meeting and keep it for a year, you must allow all persons to attend via video conference if they want to, but you still must have a physical location for the meeting. And then one of the quirkiest parts of the law, and we might have talked about this before, is that if you hold the annual condo election meeting, this only applies to the condo election meeting. If you hold the condo election meeting via video conference, then a quorum of the board of directors must physically attend the annual meeting at its physical location. Not really sure what the reasoning for that is, but that is a requirement. We might have talked about it on the last podcast or another one.
Yeah, I think that, to me, that always confuses me when that's come up, because it's a members meeting. It's not a board meeting. So I'm not sure where the reasoning was behind that, but I think that's the problem when you have obviously you're engrossed in this whole ecosystem, as am I. But when you have legislators that are not understanding how this entire world works of associations, it's hard for them to parse out some of these things that to you and me and most people in this industry, it's very obvious. But that one confuses me for sure.
Well, the only logic I can put to it, and this is total speculation, is that somebody complained to their legislator that these board members never attend the annual meeting in person, and we can't yell at them right to their face. They hide behind the video. So I think this was the solution. We'll see how well it works. There is no indication of what the penalty would be if you don't attend. But right now, that is the law. So upcoming annual meetings in your condo, if it's video conference, then 3 out of 5 or 2 out of 3, whatever your quorum is for your board, plan on coming to Florida for the meeting, because that's a requirement now.
So then, as you were mentioning, it's probably going to filter over to 720 HOAs and 719 co-ops at some point, I'm assuming.
I would think so, unless we can maybe stop it and show that this doesn't really make any sense. So that was one of the bigger changes that people are talking about. There were a lot of changes. One of the other ones that was kind of a little bit interesting, I think we know what they were trying to do, but again, with poor drafting, they've actually created a bigger problem as lawyers look at it. And that is, again, condo only. They changed the statute to say that a board, in addition to using its best efforts to invest its association funds prudently, which has always been the standard, it now says an association may invest reserve funds in certificates of deposit at a community, savings, or commercial bank and savings and loan, or a credit union without a vote of the owners. Okay, well, that sounds okay. What I think they were intending here is, without a vote of the owners, the board can invest its fund, the association funds, in prudent investment vehicles that are conservative and not risky, such as treasury bills, which are a very good investment that pay higher interest and is a good way to preserve your money and protect it. And it's guaranteed by the government. The problem is, in drafting this, there's a maxim in the law, which can't ever remember the Latin phrase, exclusio includus, exclusio, whatever, which basically means if you create a list of you can do X, Y, and Z, and you don't preface that with you can do X, including but not limited to, you can do X, Y, and Z, then it's presumed that you can only do X, Y, and Z. So by saying you can invest the funds in these 3 vehicles, savings bank, commercial bank, savings and loan, or credit union, without saying including but not limited to, without a vote of the owners, are they suggesting that to invest it in something other than that, you do need a vote of the owners? I don't think they intended that, but that could be the interpretation given. Not all attorneys believe it. I tend to think you can still invest it in prudent vehicles without a vote of the owners if your documents don't require a vote, but the statute could certainly be interpreted differently. So another interesting, head scratcher.
It's always fun to watch the little gymnastics of the wording of every bill, and inevitably there's some tweaks that come to clean it up because there's some community out there is going to come back and with that exact question, does this mean? And somebody has to settle that for everybody to understand. A couple of the other changes that I thought were interesting is obviously with the website. You brought this up. Now it's 25 units or more have to have a secure website with a firewall.
With 25 or more units has to have a official website meeting certain criteria, up and running by December 31, 2025, which is basically, a month and a half, month and a few days from now.
Right.
And you then must post on that website certain documents, not all the documents. The former law said 150 more units. So now even relatively small condominiums have to have this website and comply with the requirements.
Yeah, I like this one actually. I think it's better for owners. They have easier access. There's always a barrier if you have to go through people. to get something. There's always a lag time. And even if they're not trying to be a barrier, that's just the nature of the
Yeah,
world.
I agree with you. At the end of the day, I mean, this is the way of the world. Everything's in the cloud. I think this is going to hopefully cut down on the intentional or unintentional dragging of the feet of getting official records. And these days, you get official records requests that are literally the kitchen sink. And it takes so much time and manpower and woman power to compile these records. It's almost becomes impossible. So if we just put it on the web and the cloud, you'll just say, go there. So at the end of the day, while this is going to create a little bit of a burden, I think ultimately it's going to solve a lot more problems that it creates.
I think now, I think websites, the cost of that has come down a lot. It's not as prohibitive as it was a few years back. Obviously, it has to be a secure one. It has to have a firewall where password protected to get into those areas. But I think the costs have come down where it's easier and easier. It just makes more sense, I think, for an association, even under 25. Now, if it's four, if it's you and your neighbor and a couple buddies that live in a fourplex, okay, maybe that seems like too much. But even for under 25, I think it makes sense. It's an easier way.
I got a question for you, which will show my technical ignorance. I know you're in the tech business. Everything's in the cloud now. I mean, our entire office system is cloud-based with thousands of gigabytes of data. Is there a limit to this? I mean, if you times this by all the world.
Yeah. That's why there's such a drain on the energy grid right now, because to store, they have these huge data centers. It eats up so much energy. And now with the advent of AI, that actually is exploding. So that's where it gets kind of scary, because more and more is going to the cloud, which is just a giant data center or a group of data centers.
So it's not really a cloud. There's a physical location where this stuff is.
Yeah, it's in a data center. There's a server, and that is considered the cloud. All it means is it's not on your physical machine in your office or your home. It's on somebody else's machine somewhere. And I actually just saw something, I think it was yesterday, on quantum computing. Now, you think that AI is going to be eating up a lot of energy and a lot of resources. Quantum computing is the next level, and I'm not going to get all geeky on you, but it's impressive, terrifying, but impressive. All of these websites with the secure backside, are basically bank-rated security. I mean, any of the main players in this vertical have to have bank-rated security. Well, what I was watching yesterday, they're saying that with quantum computing, and I don't want to scare everybody, which I know I'm about to, but with quantum computing, it is so far advanced that it will be able to look back, and all of our password protected data and all of our secure data almost will be just like an open book in the future at some point. So remember that if you have something that's secure right now, keep thinking, just like when you type an email, how is this going to read if I'm sitting in court, or how is this going to read if this is on the front page?
Yeah, and
it's the same thing with whatever you're protecting behind a password. At some point in the future, that might be accessible, period. And there's not much you can do about it.
We know, that all this is usually used for good, but there's a bad element that will use this technology for fraud. And so that's only going to get longer.
Yeah. And there's always been this kind of a teeter-totter back and forth of, okay, every time the bad players come up with a way to penetrate, the good players find a way to block, and vice versa. And it's just this back and forth. I think once quantum computing, which from everything that I've looked up, we're talking not too far in the future, 5-10 years in the future, where that teeter-totter might be just blown to smithereens. It might be sawdust on the grass, and it'll just be open. So just remember that, everybody, when you're putting something behind a firewall, behind up in the cloud, and it's secure for today, not necessarily 5 years from now. So something to think about. I did want to touch upon a couple things that I thought were kind of interesting. So CAM licenses, this one, I don't know if I'm shocked that it actually came down to where somebody had to put this down in writing. I thought this would have been an obvious one, but if a CAM has their license revoked, that they may not have ownership interest in a management firm for 10 years. That's kind of a newer thing.
Or be an employee.
Right.
Okay.
Right. Which
And
I
that
thought would have been
be-
kind of an obvious thing if you're, it's like if you're disbarred, oh, but I'm going to start a law firm. I just won't be the attorney. I mean, to me, doesn't that kind of make
well, I
sense that that
get
would have been
that.
that way?
What, again, reading it literally, you couldn't be the janitor of the management company's office
Right.
if you were employed as the janitor, if your license was revoked. So it's basically, you can't even touch the industry
Which,
if your license is revoked.
which makes sense. I'm just shocked that it took somebody to actually say, oh, this isn't obvious. We're going to have to put this down into writing. So now looking forward, what do you see kind of coming down the pipe? I mean, obviously there's a few
Well,
things that are being talked about out there, but if you can address those.
yeah. One that got a lot of press, but as of just checking 20 minutes ago, I haven't found that a bill has been filed, is Representative Porras, Porras, I believe, from the Miami-Dade area. He's a House of Representatives. He got a lot of press earlier this year for saying that he was going to introduce a bill like doing away with HOAs. He previously, in previous sessions, he was one of the primary authors of the Homeowners Bill of Rights, which was really, well, maybe sounds good, really was designed and did negate standard prohibitions found in many HOA documents that are reasons that people move into HOAs. The prime example was no commercial vehicles in the driveway or no trucks in the driveway, or commercial trucks in the driveway and things like that. A lot of documents say that, but his legislation for Homeowner Bill of Rights in previous years prohibit, under certain circumstances, will prohibit the enforcement of those things. So his idea of the Bill of Rights is to take away standard, normal restrictions found in most HOAs, which are the reason people like to move into HOAs, because there's uniformity, consistency of appearance, things like that. It's more of taking away those. And now the latest, news reports and quotes from him are that he believes HOAs are a relic, that has an experiment that has basically reached the end of its useful life. He called it, quote unquote, a failed experiment. So the thought was he's somehow going to do away with them. Now, again, I haven't seen a bill filed, and I'm not disparaging him by any means, but there's a lot more to HOAs than let's just get rid of them. There's a lot of governmental agencies that require HOAs, water management districts require them to be created to maintain that. And if you did away with it, I mean, there are other vehicles that could replace them, but I don't think a blanket let's do away with them is really a well thought out idea. But unfortunately, what we may see is more, Bill of Rights, which is just a death by 1,000 cuts idea of taking away HOA standard provisions. And, I understand there's proponents for that, but, most people, and I would say in our industry, 98% of the people, they move into these and they have no problems. It's the 2% that cannot fathom someone telling them what to do, even though they agreed to those rules. And they sit in the legislator's office and bang on them until they react. And then 98% of us are like, there was never a problem. None of us go there and say, hey, representative, I live in an HOA and everything's wonderful. They never hear that story. They only hear the horror stories, which are really, when you dig into them, there's a lot more than what the person was saying.
Yeah, the squeaky wheel sometimes squeaks for a reason, and it's not so obvious. But that's the thing. When it comes down to it, you have a choice to move into an HOA or not. And if you move into one, well, you've made that choice to abide by all of those rules. Otherwise, why move into it in the first place?
And more importantly, the HOA documents themselves and the statute already provides a methodology to change the rules. Okay. So if you can get the necessary majority of your fellow owners to agree that the no commercial vehicle in the driveway rule is not one that is good for ABC HOA, then change it. But don't have the legislature blanketly say this rule's no good for anybody. That's just, doesn't make any sense.
That's sometimes I've gotten into some conversations about the Constitution, and I feel the same way. The Constitution was set up with ways to adjust it and change it and modify it. So you can't say, oh, the Constitution is bad. No, it already has it to where if people disagree with something in there, you can change it, whether it's the federal Constitution or the state Constitution. Same thing. There's always a remedy. And when you go down to that microcosm of managed neighborhoods, they all have that same thing in there. It's built in. It's just a given that you can change these things if the majority wants it. But if
Right.
you're the minority and you just want to squeak, then maybe an HOA isn't the place for you to live, and you do have that choice. Nobody's forcing you to be in one. So
I agree with you 100%.
now there's some laws that I find interesting. They might have impacts on communities that people don't realize. There's the privacy about video recording within the community. There's open carry now, which has gotten a lot of press over the last how many months in Florida. And then of course the dangerous dogs. That's another one. Poor situation where somebody had a run-in with a dangerous dog, made its way into the legislature's ears. But if you could touch upon those a little bit, especially I think the open carry, what can an association do?
Well, that is a hot topic. And here's what a lot of people don't understand. You have a constitutional right to keep and bear arms. You can debate what it really means. I get all that. But the Constitution is designed to prevent government from infringing on certain rights. Okay. That means state and federal government and local municipality government. It doesn't mean a private deed restricted community cannot inhibit rights that otherwise the government would not be able to do because it's a private contract. We were just talking about it. You get enough owners to vote to say, well, you can't open carry in my private gated community. That's lawful. You can do that. And it would be legally enforceable. I have a lot of communities asking about this, but I haven't had any really come to me and say, we got, Billy Bob walking around with his open carry gun. I'm a gun owner myself, and I think and not saying anything against it, but most responsible gun owners, I don't think they want, even if they can open carry, I don't think they generally do, except if they're out in the woods hunting. Okay. They don't walk in the mall with a shotgun because, like it or not, it may be your legal right, but it certainly is going to put people ill at ease. So a community could prohibit open carry. I think the difficulty is if you impose a rule and you don't enforce the rule, it creates potential liability. So here's my quick advice. If it's not currently a problem, you don't have people doing it, I'm not sure I would run out and impose the rule just yet, because you will be creating an issue that maybe nobody was really worried about, and you will divide the community very quickly on gun rights versus, gun control, etc. You could prohibit concealed carry in your private community if the declaration was amended to do so. Again, enforcement will be very, very difficult. And if something bad happened and they said you didn't even enforce your own rule, you've got a liability situation with your board that did not enforce a rule. So don't take on a burden that you don't intend to, meet.
Yeah, I think one of the things that people forget, these are private entities. Yes, there's communal property. Yes, you're all in it together, but it's still a private entity, private property that you've all signed on to these rules for. It's not like you're walking on the sidewalk of a public street. That is a very different situation than a private.
Yeah. Another example that is often confused is, I recommend kind of a balance here. You could prohibit political signs in the community. You can prohibit that if you amend your declaration. And people say, well, what about free speech? The Constitution guarantees free speech won't be infringed by the government. This is not government. And there's a local court case from Southwest Florida from many years ago that upheld the right to prohibit signs. Well, I don't know if it was a political sign, but it was a sign. I don't recommend communities really do an outright ban. I believe there should be a balance. You can put a limited number of political signs during the election period, before and after. I think is a balanced rule if you're going to go down that path.
And just like a lot of communities, they'll have restrictions on if you're selling your home, you can have a certain type of sign, for sale sign, or maybe they don't want you to have one at all. It doesn't mean you can put, the searchlights and, a big balloon gorilla.
That Orly thing that we see, whatever, I don't know what that's called, but
it's bizarre. That's what it's called. Bizarre. Everybody knows what you're talking about though. But yeah, I think the big thing that people have to remember though, that these are private. This is not public area. This is a private community. It's not a public community. So, and then what about as far as, everybody's got not everybody, but a lot of people have either the Ring doorbell with the camera or some kind of security camera. And again, infringing on people's privacy versus, an homeowner wants their security.
Couple of things. In a condominium and a cooperative, for the most part, almost always the exterior of the door and the frame are actually, not always, but almost always, they're actually common element. And the board and the governing documents almost always will say, you cannot modify or improve or change the common elements without a board approval. So technically, you could probably prohibit Ring doorbells under that set of rules, okay? In a single family home, the documents would not go that far because they own the whole home. But here's my practical advice here. First of all, let's talk about the right to privacy. When you're walking around the common elements or walking down the hallway of your condominium building where there's doors on either side, you have no right of privacy, okay? You're in an open space where anybody could be. I could stand at my front door, set a chair in it, and watch that hallway 24/7. And that's effectively what you could do with a Ring doorbell. So it's really not a right of privacy. I mean, it feels that way. I get it, but legally it's not an invasion of privacy when there is no expectation of privacy. And one way that some statutes look at the expectation of privacy, and I think I've mentioned this at meetings with, seminars with you before. One of the rules of thumbs is if you would feel comfortable disrobing in a particular location, you probably have an expectation of privacy there. And if you feel, comfortable disrobing, walking down the street of your HOA, well, you're probably going to get arrested.
Or you live in the villages.
Right. That was a good one. So there really is no expectation of privacy. And I tell people, look, I have a Ring doorbell. They become so, ubiquitous. Everybody has them. Cameras are everywhere in public. So while people don't like them, I don't think you could really outright prohibit them unless you wanted to say, we're not going to let you modify the exterior of your door, which you could do potentially. But you might create a backlash of people that feel like it's a security measure.
Right. Now, taking that one step further, have you had any conversations with communities regarding drones? That's kind of something that's developing lately. Have you had any issues with that?
Yeah, that was a big deal when they first came around, and I'm not an expert on them. I know there are drone laws, and I do have some communities that a couple of years ago imposed that you can't have a drone flown outside the perimeters of your single family lot. So you can't fly it over the whole community, and that's an enforceable rule. And there are also statutes specifically for the drone industry of FCC requirements and things like that. But yeah, that was a pretty common rule that you can't fly a drone on the common area or common elements. It has to be confined to your single family lot. And that's a little different. For example, if you're in your backyard with a fence around it, then there is a much more of an expectation of privacy because you know, you don't expect a drone to be flying over the top of your house, except, you know, I mean, with satellites these days, I guess they can pretty much read anything they
Yeah.
want. Yeah.
Yeah. It is getting a little scary, a little scary. So now, again, looking forward, is there any other big changes
Yes.
that you see kind of coming?
Well, there's one bill that I want to alert your audience to that I think is significant. HB 255, filed by Representative Snyder, and its companion, Senate Bill 638, filed by Senator Turnbull. Well, you read the preamble to this bill, which is just like the introduction, or you read the simple bill description before you read the details of the bill, it seems to be a very innocuous bill, and it's for condos only. And it basically, what you would glean without reading the bill is they're just basically creating a couple of new types of official records that have to be kept and delivered to the state about turnover and things like that. Well, when I read the bill, the meat of the bill, and I think the real purpose of the bill, is to amend 718.124. That's Florida statute 718 period 124. And there's a companion 719 version as well. And let me tell you what's important about that. 718.124 has been in the statute for many, 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 many years. It basically says if you are going to sue the developer for a construction defect in the construction of your condominium building, despite any statute of limitations, the statute does not begin to run until turnover occurs, when the owners have taken control of the board. And it then says they have 4 years from the date of turnover to bring a construction defect claim, which makes sense because the owners don't control the board. They can't control the association resources to hire an engineer. They would have to just do it all privately on their own. Some people would pay, somebody wouldn't. So this was I liked this bill because it held developers accountable and made them subject to the new boards doing its due diligence to determine that maybe the roof wasn't put on right, and they had a reasonable period of time to bring that claim. What this bill now does is it says, well, you still have the 4 years from turnover, but it doesn't apply to Florida statute 9511(3)(b). Guess what 9511(3)(b) is? That's the construction defect statute. So this will accept the construction defect statute from the 4 years from turnover and revert to what it says now, which is for other construction defect, non-condominium, you have 4 years from the date of completion of the item. So that theoretically could mean, let's say you have and I'm getting a little wonky here, but this is important. Let's say you have a condominium building that was built in 2025. It was built and it was CO. It was completed, but it doesn't turn over till 2031, or let's say 2030. It doesn't turn over to control till 2030. Well, the 4 years will have run. From the date of completion, it would have run in 2029, and the owners will have no ability to recourse against the developer for that construction defect. Whereas the law today says, no, your construction defect statute runs from 4 years from turnover. So you would have 2020, 2030 to 2034. So theoretically, a building could be turned over while the statute is already run, and the developer, you have no recourse against the developer. This is a flat out gift to the construction industry. Okay. And they've been trying to get this stuff done for years and years and years. They've been quite successful in taking away consumer protections in this regard. They've done it for HOAs for sure. This is the remainder. They're going for the last bite of the apple. And I would strongly oppose this bill. And I hope others will understand its real import.
So what do you think what would you say the betting odds are right now?
Well, you know, big lobbyist industries, and construction is one of the biggest. When they don't get what they want, they eventually seem to get what they want, or most of they want. They might not get it the first shot or the second or the third, but they're going for it here. And, you know, they usually end up getting what they want unless the other side really puts up a fight. And I think there will be a fight on this. I'm hopeful.
Yeah, because they can stretch that out too if they really wanted to. Because
Yeah,
turnover
Congress-
usually is, exceeds
7 years.
90% occupancy. So they
Yeah,
could
I know,
stretch that
yeah,
out
they're
in the
triggered.
edges.
I would turn it over earlier, but theoretically the developer could, under, certain circumstances, stretch it out beyond the statute and you have no recourse.
Right.
So I would keep an eye on that, Bill.
Definitely. Definitely. Well, as always, love these chats. You're so informative. I really appreciate it. And I hope this won't be the last time that we're discussing all the fun side of the legal world.
Yeah, I appreciate it. I'm always happy to participate on the new and exciting world of community association law.
All right. Excellent. Hey, thank you, Richard. I appreciate your time.
Thanks a lot, Derek.
All right. Take care.
Bye-bye.